talks.
I'd like, if I may, to slightly change the focus of attention and to look at some academic material, which there is a separate bundle, Authorities Volume 4, tab 65 to 71, but it can be found at EF 1093. 1093.
Thank you.
That page lists the various articles which we have collected. I'm not obviously going to take your lordships through all the articles. The first article is by Douglas Brodie from the University of Strathclyde, who comments on HXA. He's critical of the Court of Appeal's decision on the basis that it offers little clarity and is out of kilter with Poole. And can I draw your attention to his conclusions, which we have at 3379, where he says the difficult area of law, successive judges have taken different approaches. The approach advocated in HXA assumes that the law will develop through a not insignificant amount of litigation. He then quotes, then says at the end, I'm not convinced the Supreme Court would view matters in the same way. After all, the general trend over the recent years has been to keep public authority liabilities decidedly within bounds. He also goes on down the paragraph to say he's not convinced there's a difference between a general and a specific duty when it comes to demonstrating that assumption of responsibility has taken place. In both cases, it's an exercise in looking to see what the defendant has done beyond the mere exercise of their statutory functions. There is then an article written behind the next tab at 3381 by Tom Cornford. This was written before the Court of Appeal's decision. So he was reviewing the decision of the lower courts, including Mrs. Justice Stacey and DFX. And essentially what he said was that the outcome was unsurprising. That's before the Court of Appeal. And he, quote, said, and the result follows naturally from the position staked out by the Supreme Court in Michael, Robinson and Poole. There is a case note, a useful case note, which I'm not going to take you to specifically, by May Martin and Hannah Whitehouse, which is at 3393. And then at 3399, there is a commentary by Francis McManus at the University of Stirling. Her comments can be found at 3402. She deals with Smith and Littlewood's Michael, Stovin and Wise, but also a case called Tyndall versus the Chief Constable. It's in our bundle of authorities. It's consistent, we say, with our submissions, but I ought to tell the court that the Supreme Court has given permission to appeal in Tyndall. Although we say the reasoning is sound, the matter will be considered in due course by this court.
Well, I think I was on the panel. This is a case about, it hinges, as I recollect, on the police intervention resulting in the removal of a person who was, up until that point, warning motorists about the danger.
Yes. That's true. The facts are, of course, very different. But the analysis that...
Yes, I mean, it's rather, in summary here, failure of police to warn road users of danger actually isn't the critical point.
Yes.
It's the fact that the police effectively removed...
They did something.
The argument is that, in effect, the police removed a protection against danger.
Yes, I appreciate that may well be the argument, because they actually did something,
yeah,
as opposed to in Stovin and Wise, where they didn't do anything, but arguably they should have done something. Yeah. No doubt the arguments will focus upon whether that they're doing something in those circumstances is different from when they didn't do anything at all.
Yes, I think arguably they've made the position worse, which is the added point rather than it just being an assumption responsibility case. I think
That's consistent with the capital and counties line of authority about the fire brigade, where normally speaking the fire brigade don't owe a duty of care to anybody except if they arguably made matters worse. And in the capital and counties case, they switched off the sprinkler system, thereby actually harming the claimant's prospects.
That's the analogy drawn by the appellant in Tyndall.
Yes. Well, I don't think I want to argue that case as well at this stage or at all. What I would say is that Lord Justice Stuart Smith in Tyndall, whatever the result, performs extremely valuable analysis of what the law is, which recognises, we would say, the new orthodoxy. It may be that on the facts it doesn't come within the definitions as he provides them, but it is a very orthodox and helpful judgment to that extent. What she says in the right-hand column at 3403 is, as far as YXA was concerned, whilst it was certainly arguable there was a sufficiently close relationship between the claimant and the defendant, local authority during the period the claimant was being voluntarily accommodated under Section 20, for the court to find that the defendant had assumed responsibility of the claimant after that period had ended seems to the author to be an increment too far, and that is, of course, the case here. One could argue that even if there had been an assumption of responsibility on the part of the authority while the child was being voluntarily accommodated, after that, even that's a uncertainty, after the period of voluntary accommodation had ended, the authority had simply failed to rescue the claimant by invoking its powers under the relevant legislation. In the last analysis, whilst the authority may be negligent, it had not made matters worse. There is, at page 3405, there is an article in the Cambridge Law Journal by Jonathan Morgan, who writes quite often in this area of the law, and there's a particular passage which I'd like to take, well, passages I'd like to take court to, if I may. And it's at 3405, halfway down the page. He says, in HXA, the Court of Appeal warned it would be inappropriate to offer general guidance on such a fact-specific question in a striking-out case. They decided merely that on the pleaded facts, assumption of responsibility could arguably be proven. While with this important caveat, it nevertheless seems that HXA took a wider view than other leading cases. The court first erased the bright line rules that Stacey J. had identified in the court below. While it is certainly true that a local authority assumed responsibility of children who had actually been taken into care, Barrett, it did not follow that assumption was confined, this is a quote from Lord Justice Baker, to cases where it acquires parental responsibility and where authority provides accommodation does not mean an assumption of responsibility, nor was the duty's temporal assent necessarily confined to a limited period. In one of the cases heard together in HXA, the authority had taken a decision to implement measures to protect the children, but then failed to undertake the keeping safe work. Stacey J. had been unpersuaded by, and I referred you to this passage, by what counsel said is his best point. But Baker J. thought it was at least arguable the local authority was responsible for the children. But this seems hard to reconcile with a clear decision in Tyndall, which I've just referred to, that an ineffectual attempt to remove a danger does not generate an obligation to continue the attempt, i.e. positive duty. If actually commencing the work but doing it incompetently and incompletely creates duty, why should one arise at the prior stage of resolving to undertake such an action? Moreover, in Stoven and Wise, such reasoning was prominent in the dissenting speech of Lord Nichols, but did not dissuade Lord Hoffman from his famous restatement of the omissions principle. Lord Nichols emphasised the Norfolk County Council, being well aware of the dangerous road junction, had decided to act and had never changed its mind. The matter had simply been allowed to go to sleep and overlooked. This aspect of Stoven and Wise was not discussed in HXA. It says Tyndall was not even cited. Well, that obviously caused us to bristle, and we had in fact cited Tyndall, but the reason that it wasn't on the list of authorities in the skeleton argument was it hadn't been decided when they were submitted, so we did cite it in fact. Important factual differences exist. Baker LJ emphasised how common it is for local authorities to be involved with vulnerable children over a number of years, with the circumstances varying widely. Thus, what a complex exercise it is to identify assumption responsibility. The facts of the highways cases were simpler, lacking any such extended interaction between the claimant and defendant. Another observation concerned the Dyson axiom, proclaimed and implemented precept vital for the rule of law that public authorities have no special immunity from negligence claims. When an individual would owe a duty of care on the facts of Robinson to avoid barging into passers-by, then so do public officials such as the police. The sting in the tail for claimants is that public officials do not have any additional liabilities, either at common law, exemplified by Michael. And this passage is helpful. That makes sense when the police, etc., are doing things that individuals do all the time, driving cars, or might plausibly be doing, chasing thieves, Robinson, or could just about conceivably be doing, receiving a call for help from a desperate victim of assault, Michael. But the analogy between governmental and private defendants breaks down entirely in family cases like GN versus Poole and HXA. It seems most unlikely that any private individual would intrude on another family's affairs over a period of years, as local authority social workers are frequently required to do. And even if, in violation of social mores, things this were to happen, a concerned individual obviously lacks the extraordinary legal powers enjoyed by local authorities, ultimately permitting removal. We can put it this way: a brave enough private individual might have stepped in to protect Joanna Michael against her former partner's violent attack. Partly the observation the police have a virtual monopoly on force, forest and steel, but no citizen could have taken the claimant's HXA into protective custody. I think that's all I need to take from that article. At EF 3424, there is the article Tafaris and Steele. The relevant passage has been referred to in a number of cases. I don't think I need to go back over it, but there it is for your lordships. And last but very much not least, I come to the article written by my Lord Sales at page 3408 on the history and theory of assumption of responsibility delivered to the Western University, Ontario on the 26th of September 2022. It is an article which is concerned primarily with the recovery for pure economic loss in negligence, as I understand it. But my Lord does say in this article that the concept should not be overextended. Can I take the court to EF 3412 at the bottom of the page? My Lord says, in terms of modern doctrine, the concept of assumption of responsibility has escaped the confines of pure economic loss. Given its historic antecedents, this is not surprising. The questions arise as to how far any satisfactory unifying principle can be stated to cover all such cases. Following the decision in Michael, for example, there has been much consideration of the circumstances in which the police can be said to have assumed positive obligations towards particular persons. That footnote 11 refers to Tyndall. Similarly, the idea of assumption of responsibility has been used to try and identify when a non-delegable duty of care arises. That's the case of Woodland. I question the extent to which a unifying theory can be applied across all the contexts in which the idea of assumption of responsibility has been invoked. It seems to me that the core pure economic loss cases have a distinctive rationale based on the availability of an opportunity to bargain which justifies the imposition of liability. How far that underlying idea can be carried outside the present context is a matter I leave for another day. And then at 3418, after an extremely helpful analysis of the development and evolution of assumption of responsibility, our Lord says at the top of the page, 3418, so I contend that the historical pedigree and theory behind assumption of responsibility as a concept is sound when applied in the class of case where the assumption of responsibility is grounded in a direct relationship between claimant and defendant, which gave the defendants a real opportunity to bargain over what he was prepared to do for the claimant and the extent of the liability, therefore, which he was prepared to take on. However, there is a danger of dissipating the moral basis that provides for imposing liability and its determinacy as a concept by trying to use it in an overextensive way. My Lord comments on Professor Stapleton, who wasn't very kind about the concept of assumption of responsibility generally. It says much ink, judicial and academic, has been spilled in attempting to identify the precise circumstances in which an assumption of responsibility occurs. There is force in Roderick Bagshaw's observation that critics of the idea have perhaps been overly wedded to classical forms carrying checklist criteria, drawing the conclusion that assumption responsibility must be defective if all applications of it do not involve the presence of fact satisfying some other concept such as promise or invited reliance. Bagshaw argues that assumption responsibility is better understood as a category including a cluster of examples that are similar to each other in overlapping and crisscrossing ways. This seems to me to capture the reality that assumption responsibility becomes difficult to pin down if one moves too far beyond the core category of cases I have been concerned to. We comment in our printed case, perhaps for your Lordship's note, at EF 1002 to 1003 on the article written by my Lord Sales. May I come finally, and relatively briefly, to looking at the authorities' volume with guidance and reports, and drawing the Court's attention to the guidance that was given up pursuant to the Children Act, and we can find that at the relevant part I want to refer to is 3231, under the heading Matters to be considered by local authorities before making an application for a care or supervision order. There is a useful passage which follows there, explaining what local authorities have to consider before making an application for a care or supervision order. There's also a passage dealing on the next page with the local authority's duty to make inquiries under section 47.
I'm sorry, I misheard your page quotation.
It was 3231, my lord,
and
had 3232. And the paragraphs begin, internal paragraphs 3.22
Thank you.
to, and the other relevant paragraph is 4.73 onwards. It's simply a helpful explanation as to how these powers are to be exercised. And then more up to date, behind tab 63 at 3258, we have included the independent review of children's social care, which is a report in May 22. And may I commend the attention of the Court to the executive summary, which is at 3269. Where this report, which was independent, of course, so it may be that there'll be different views in due course expressed about what is best practice, what is good for particular children or not. That may evolve, it may change in the future. Another government might, for example, have a different view. But what was said was that this is a once-in-a-generation opportunity to reset children's social care. We need a system that provides intensive help to families in crisis, acts decisively in response to abuse, unlocks the potential of wider family networks, i.e. not necessarily mother and father, to raise children, puts lifelong loving relationships at the heart of the care system, and lays the foundation for a good life for those who have been in care. We currently have is a system increasingly skewed to crisis intervention, with outcomes for children that continue to be unacceptably poor and costs that continue to rise. And it suggests a radical reset is unavoidable. And under the heading on that page, A Revolution in Family Help, it suggested there must be a fundamental shift in children's social care response, so they receive more responsive, respectful and effective response. To reduce the number of handovers between services, we recommend introduce one category of family help to replace targeted early help and child in need work. This service would be provided by multidisciplinary teams made up of professionals such as family support workers. I think what one can derive from this, and the paper is interesting in putting the emphasis on family help, is that it is simplistic, with great respect, to suggest that children are either in the community or they're in care. And this encourages the development of a range of responses, even beyond those powers that can be now exercised, which will tend, and we referred to quotes in our printed case, more to encouraging the nearest thing that can be achieved by way of a family. It may not be the conventional family. There may be inadequacies in many respects with a family, but it may often be in the child's best interests to be with somebody that he or she at least acknowledges as being a familial parent or quasi-parent. That emphasises how difficult this job is, how much intervention may or may not be required will of course depend on the facts, as I indicated at the start, often on imperfect information, which these social workers, faced with problems at the bottom of society, usually have to deal with. My Lords, our submission is that...
not necessarily confined to the bottom of society.
Not necessarily, no. I said mostly, my Lord, but your Lordship's quite right. What our submission is that all these claimants in particular, most of these claimants in these cases deserve considerable sympathy and understanding, and they should receive as much help as is reasonable in the circumstances. But that does not translate, we submit, into an actionable duty of care in circumstances such as prevailed in these two cases, nor more widely. We, of course, accept that there may be unusual circumstances where there is assumption of responsibility, but our submission is that those will be very rare, and that generally speaking, whatever one may hope and expect social workers to do in these difficult areas, it should not translate into either a duty of care or even to be considered an assumption of responsibility. Well, those are our submissions.
Thank you very much, Lord Fawkes. Ms. Gunn.
Please, Your Lordships. I begin with what the issues are raised in this case, which are set out at EF 37 and at EF 530 for the two cases. They are the same issues, whether it's arguable the local authority and its social workers owed each claimant a duty of care by way of an assumption of responsibility, and that's the first issue. Then whether it's arguable the scope of duty included taking reasonable steps to remove the child from the danger the family home presented, and then thirdly, whether the claim should have been struck out, so the strikeout provisions. In both cases, the
I do apologise, I missed the page number. I'm terribly sorry.
I'm so sorry. EF 37 at page 43 are the issues, and EF 530 at 533 to 4. That's the party statement of facts and issues. But I begin with that as the starting point that we need to concentrate on. I will come to the individual facts of the case. My learned friend hasn't referred to those at all, and they are relevant to the issues in the case, and I will come to those later in my submissions. But I start with the fact that in both cases, the central issue is to examine when a social services department or social workers for whom they're vicariously liable can owe a duty of care to a child in respect of child protection functions, because that's really what we're looking at.
I mean, I wonder whether it might be said that separating out issue 1 and issue 2 is entirely helpful, because to ask whether there's an assumption of responsibility in the abstract may be rather difficult.
Well, those are the issues the parties agreed.
Certainly.
I would agree that unless you can establish an assumption of responsibility, it's once you've established it, you've then got to look at the scope of the duty. I think that issue was directed to possibly the keeping safe work and other aspects as to whether the scope included applying for a care order, but those are issues which would be further down the line in our submission. The primary issue for this court is to assist with where there can be an assumption of responsibility in relation to social services functions in protecting children, because that's the issue which my learned friend says is now clear following Robinson and N. Poole, and that the judges at first instance were able to simply apply it and it's quite clear cut. the Court of Appeal obviously disagreed that it wasn't clear-cut, and the number of cases awaiting identify that certainly on the ground, the parties and practitioners are not finding it easy to apply where there can or cannot be assumption of responsibility in the context of social services provision. And I'm not looking for an excuse in relation to the pleadings, but the difficulty in pleading cases is not confined to our team. It's generally identifying what the court requires in order for claimants to establish an assumption of responsibility that gives rise to a duty of care. Doesn't seem clear to practitioners, didn't seem clear to the Court of Appeal. My learned friend said it seemed quite clear to a deputy master and Mrs. Justice Stacey, but we would say it isn't clear, and we would want to examine the history of how we've got to the position in Enham Pool to see what light that throws on what the responsibilities of social services departments are and where a duty of care can be owed by social workers in their professional capacity, because it is a new area in the sense of the first case in which this point was examined was Exham, Bedfordshire, which may be nearly 30 years ago, but in the context of legal history, it's a very recent history, and it does bear looking at how the courts approached it from then onwards to see where we have got to now, and have we got clear lines, and where are those clear lines drawn in relation to social services duties to children outside a breach of statutory duty, which the only time that's been argued was in Exham, Bedfordshire. Since Exham, Bedfordshire, it's been established and accepted that alleging a breach of statutory duty is not a fruitful way forward for claimants in relation to these claims. We do need to show a common law duty of care. So I start...
At some stage, could you assist me, not with the facts of this case, but just as a general proposition, what is the clearest example that you can conceive of an assumption of responsibility by a child protection authority? Now, leaving to one side Barrett against Enfield, but just to give an example of an assumption of responsibility.
Yes, I've been giving some thought to that, and what I would say would be an example where it'd be very difficult to say there wasn't a common law duty of care and an assumption of responsibility would be, say, a 14-year-old girl going to social services, asking to see her social worker, saying, I'm being sexually abused by my stepfather. Please, can you help me and do something about it? Social worker saying, how terrible. Yes, of course I'll do something about it. I'll make sure you're moved from home as soon as possible. I'll make arrangements for you never to be abused by him again, and then doing absolutely nothing. It's very difficult in that situation to see, and it is to do with the personal relationship between a particular child and a particular social worker who assumes responsibility in relation to that child for keeping that child safe. It's difficult to see how, on any common law principles, there wouldn't be an assumption of responsibility in that kind of situation. And that takes me on to...
Just before moving away from that, breaking that down, that would be vicarious liability for the social worker who had assumed responsibility. Yes. But if the local authority had then, or the Child Protection Authority, you say, had then had that relayed to them, and they had also given the same assurances that the social worker had given, you say that's an assumption of responsibility by the Child Protection Authority itself.
My Lord, yes, but either will do in terms of bringing a claim if there's vicarious liability. Direct duty is quite unusual in terms of any professional, any claims against professionals, because it's nearly always an individual professional. Like, it's very seldom that a hospital is itself responsible for a medical accident, it's nearly always vicarious liability for the doctor, although there are cases of the layout of a hospital in... so it will nearly always be individual social workers, although the claim is brought against the local authority. And the personal relationship between a particular social worker looking at the plight of a particular child seems to us a situation where there will be, on the right facts, an assumption of responsibility. And in that situation, and I'm going to come to reliance in the context of personal injury claims and in the context of children and adults without capacity, in that situation, in the example I've just given, there is not only assumption of responsibility, but active reliance that can be shown, because the 14-year-old goes away thinking this social worker is going to do something for me and I'm relying on them. But when you move on from that, if instead of being a 14-year-old, it's a child at home with a social worker visits and there's a report the child's being sexually abused, but the child has learning disability or a mental illness so that they're not able to specifically relate the complaint and specifically rely in the way the 14-year-old might be able to, can it be right that with that same relationship, but the only difference being that the second child can't actively rely because they haven't got the mental capacity to rely, is it then said, well, there can't be an assumption of responsibility and reliance in that case? That can't logically be right. So one has to look at what is meant by reliance in this context. But
now, in the clearest example that you've given us, we effectively have a promise or an undertaking being given by the social worker, which is then relied upon. If we just break that down, in practice, what would that actually involve the social worker doing if they were to comply with the promise that they've given? Would it involve a fairly speedy attempt to get some sort of order from the court?
Well, probably, unless the parent agreed to, there would be a number of implications. It could be that the social worker would go round to the family home and say to the mother, your daughter's been complaining about your partner. We really need to keep her safe. You may or may not know about this, but she definitely needs to come out of the family home unless you're prepared to exclude the there are all sorts of things that could be done. Or if the mother didn't accept that, which often they won't, you would have to either get an emergency protection order, which you could get the police to get, or ask if she could at least be accommodated while it was looked into, and then there might be Section 20 accommodation following that, and the placement with foster carers. There will be a number of options to the social worker, but the social worker would have assumed responsibility for doing something to protect that child from a known serious harm, which just to ignore, it's common sense that I think anybody would be appalled at the idea that social worker could simply ignore that request and not to have assumed responsibility for helping that child in that situation. So it is quite personal in terms of that example, but it doesn't, one then goes on to say how specific does it need to be. That example, I can point to the assumption of responsibility and I can point to the reliance, but do I need to do so? Because it would be illogical that I did in the context of child protection, where the most vulnerable children are those who can't go to social services and make a complaint.
It occurs to me in your example, it might be argued that there isn't, properly speaking, reliance. But you could make the example stronger, perhaps, by envisaging, say, that the 14-year-old girl tells the social worker, I'm going to run away from home because I'm being abused by my stepfather. And the social worker tells her, no, don't do that. I will do something to make sure you're protected. And the girl then remains in the home and continues to be abused, relying on while she is relying on the social worker to fulfill her undertaking.
Although it might be said against me in that example that they've made the position worse, and therefore it's an example of a different category of duty of care, if they had truly made the situation worse. But the making the situation worse is also a difficult concept, because often it's the case that by doing nothing in the situation of child abuse in the family home, one is reassuring the parents that nothing is going to be done, and it's encouraging the abuser that they're not going to be arrested. And if social workers are coming around all the time and doing nothing, for some children that will be making the situation worse in itself.
Well, why is it different in your example, where the girl doesn't actually rely on the social worker beyond remaining in the house?
There is reliance on the social worker to do something to remove her. If she then runs away, arguably that could have made the situation worse if she's then in danger. But if she runs away, in a sense,
well, that would go to, I suppose, maybe causation of. Oh, I don't know. It wouldn't go to the question of whether there's a duty or not.
well, that's why I'm trying to keep the position simple, that I would say there would be an assumption of responsibility if a 14-year-old able to explain what's happening to a social worker, thinking that the social worker is the only person who's going to help her, and the social worker says they will, there would be a clear example of reliance. And what I'm saying is it can't be right that it has to be that stark for there to be an assumption of responsibility and reliance, because the girl who's able to articulate the harm that she's coming to cannot be generally in a better position than the even more vulnerable child who can't articulate it. Therefore, it cannot be, and I'll come to how I say that the courts have described reliance in the context of personal injury cases, which I would say is different from reliance in the context of pure economic loss cases.
So your submission is that we start off with a very clear case that you say is indisputable, where you've got, as I would term it, a promise plus reliance. You're putting to one side a variation because it's not to do with assumption of responsibility, where the position is actually made worse.
Yes.
Because you don't need that.
I don't need that, because that would be a different...
And then, as I understand it, you're going to be arguing that the other situations are analogous to the promise, although there is no promise plus reliance as such. They are nevertheless sufficiently similar, and they involve people who perhaps haven't made an express promise and couldn't, on the other side, couldn't be expected to rely.
My Lord, yes, and that it can the circumstances in which a duty of care arises cannot be confined to where a child is able to articulate reliance. That cannot be the cut-off point. My learned friend is arguing there would be very rare situations, but if the rare situations are confined to those where there can be a specific conversation in which there is assumption and reliance, it is placing assumption of responsibility in the category analogous to economic loss, where there is a specific relationship and where somebody makes a promise. And I am saying in personal injury situation, which is what we're concerned with here, it cannot be as high a threshold to show assumption of responsibility. It must be lower than that. Where it is, I need to develop. But what I'm saying is one cannot rule out as compendiously as my learned friend is seeking to do, situations where there'll be an assumption of responsibility in the context of social services and social workers. Their tasks are personal to protecting children. And who else is there to protect those children? Assumption of responsibility is taking on responsibility for particular children, and their reliance may be implied rather than explicit. And to say that you won't have reliance because the children won't rely and their parents won't rely because the parents are the cause of the problem is ignoring the fact that assumption of responsibility in this context does have to be analysed differently than in economic loss cases.
If I could just take you back to your paradigm example, and the follow-up question, I'm sure, which Lord Fawkes will say, is that the Child Protection Authority was then only going to do what it was required to do by statute. And as I understand it, that argument was rejected by the Supreme Court, by this court, in Poole, page, if you contrast paragraph 70 at 1623 with paragraph 72 at 1624, namely that, of course, there's a statutory obligation to protect the child, but also the facts of the assumption of responsibility can also create a common law duty. And so you're putting forward that as a paradigm example. But can I just test it then in relation to one of the issues in this appeal is whether in HXA's case, the decision of the local authority to obtain legal advice was an assumption of responsibility. But that advice was never going to be given to the mother, never going to be given to the children, never ever going to be made available to anybody else apart from to the local authority. How can that conceivably be an assumption of responsibility?
Because one has to look at why are they seeking advice about care proceedings. It's not an arid academic exercise that local authorities can
why
do.
was it? What is the fact that gave rise to them seeking advice that would mean that they had assumed responsibility? It's not the advice itself, as I understand it. It's something anterior to that. What's that?
It's because the reason for seeking advice is that they have, we would say, assumed responsibility to do something about the concerns for that child.
And when do they do that? Upon what date, what action, what do they do to assume responsibility before they sought advice?
Well, they're investigating a child, the plight of a child for whom...
Well, that's what happens in every single case.
Well, it does, but when they get to the point of investigation that they are aware of the child's plight is severe enough...
What was the plight of what were they aware of at the time in relation to HXA?
Well, in the first instance, they were aware of the mother's ill treatment of the child. Later on, they were aware of the child's a complaint that the child's breasts were being touched by her stepfather, and ignored that because they didn't want to incur the wrath of the abuser who had convictions for a Schedule 1 offence. To say that they haven't assumed responsibility for protecting a child who's made a complaint that her breasts are being touched by her stepfather because they don't need to do anything about it because they can look at the stepfather's...
What they assumed responsibility for?
they've assumed responsibility for protecting that child from sexual abuse if it turns out on their proper investigation that child is being sexually abused. What they're assuming responsibility for is seeing whether that child is safe at home because it's been reported to them. They know there's something serious going on, but they've simply ignored it. Had they done what they should have done in assuming responsibility for that child, they would have investigated and found at that date the stepfather had already raped that child. And because by the time the investigation in 2000 in relation to the touching of the breasts occurred at the Child Protection Conference in 2000, he had been raping the child for a period of years, but went on to rape her for another 5 years. Because in January 2009, he was convicted of 7 counts of rape between the ages of 9, which would have been in 1997. They're looking at it in 2000. She's been raped between 1997 and 2004 when she's 16. He goes to prison for 14 years. Had they looked at it in 1994, she would have not been raped at all. But if they looked at it in 2000, she would have been protected from the abuse by a stepfather at the highest level of abuse. What they've assumed responsibility for is to looking into her plight as a child who's complaining that she's being sexually assaulted. And a proper investigation would have inevitably involved care proceedings, because no local authority is going to leave a child in a household where she's being raped. So the difficulty of these decisions doesn't apply. It's all very well for my learned friend to say, well, they're very sensitive and difficult decisions social workers have to make. Social workers have to investigate whether a child is at risk or not. If their investigations show they are, they put the case before the court. They don't make the decision. The court makes the decision. But it's their assumption of responsibility for that child's plight when they know she's being sexually abused, which we would say leads to the child's notional reliance, because there is no one else for the child to rely on than the social services to stop this continuing. And the keeping safe, in the course of the keeping safe work, they are assuming that they will provide some type of therapy, so it could be said to be providing a service. And in the course of that work, they will find out more about what the child needs to be kept safe from. Had they done that work, and had they done it properly, they would have found out the extent that she was already being raped by the stepfather.
But isn't this, on the face of it, very wide indeed? Because I think you're being driven to say that they were assuming responsibility to investigate what the precise position was. And if one was to say there's a duty of care, common law, for a failure to investigate properly, that would seem very wide-ranging, wouldn't it?
Well, it's wide-ranging if it's always negligent. If it's done properly, if the duty is to investigate and the level of investigation is set by the Bolam standard, it's only in stark cases such as this where the duty to investigate will lead on to the need to apply for a care order. There's no reason why...
It seems a long way from your paradigm case where you've got a clear promise, I will actually do something to stop the abuse. You're now effectively equating all this to a promise to investigate or find out what the true position is.
Well, the difference isn't, we would say, as great as that. The 14-year-old who's able to articulate directly to the social worker and the promise from the social worker, if you unpick that to the child who has reported that her father's sexually abusing her, and the social services are as aware of that as they are of the 14-year-old who's reporting it directly to them, you've got the same assumption of responsibility. We know of a child who is reporting sexual abuse. I mean, even with the 14-year-old, the social services have still got to look into it. The fact that they promised to look into it can't be the parameter, because that involves the child being able to have a conversation with them. So if you accept that the assumption of responsibility can involve assumed reliance or notional reliance rather than actual active reliance, then you're in the category of children for whom sexual abuse complaints have been made, and you're the social worker who is looking into the plight of that child. Then you've got to look into it because you've assumed responsibility for the safety of that child in the knowledge that she's made a complaint which may well be true and may go further than she's been able to articulate. So it can't depend on the severity of what the complaint is, can't depend on the age of the child who makes the complaint, can't depend on the child being able to talk about it, and it can't depend on the promise being actively made. But that shouldn't mean that the 14-year-old who has had the promise made to her hasn't had an assumption of responsibility and doesn't have a duty of care owed. I'm simply trying to illustrate it can't depend on either the age or the ability to have a conversation. It must go further than that, but it is obvious that where a social worker is taking on responsibility for a child who has complaints of being sexually abused, living in a household where the smallest amount of investigation shows the father's a Schedule 1 offender, hasn't assumed responsibility for protecting that child, I would think would be somewhat astounding to members of the public. And I was going to take your lordships to what? Sorry.
The pleading is at page 171 in relation to the second allegation. And it gives absolutely no details at all about the circumstance of the incident in which her breast was touched. It doesn't give any of the surrounding circumstances whatsoever. The pleaded case, which is the case which you have to rely upon in order to establish an assumption of responsibility, doesn't actually give any details about the circumstances in which this incident arose.
But the pleaded case is that there was a complaint of a sexual assault.
Well, where does it say sexual assault?
Well, the touching of the breast is a sexual assault.
Well, it can be accidental.
But it wouldn't be being investigated at all then if it...
It's an example of pleading evidence rather than pleading what the gravamen of the allegation actually is. You know, you're not pleading the first claimant was sexually abused by the stepfather, and she told the social worker this, and so on. You're simply telling us what, strictly speaking, it's all hearsay. You're telling us what has been recorded in the note of a child protection conference, which is very little.
Well, the first claimant had reported that Mr. Austin had touched her breast.
Well, you're not offering to... I mean, if you're looking at this strictly, you're not even offering to prove that she had reported it. All you're offering to prove is that it was noted at a child protection conference that such a report had been made.
But those are the facts that need to be proved at trial.
We have to prove the abuse, don't you? And that she reported it.
Well, that's how I've understood that was pleaded, that she had reported that he touched her breast, and then we plead that he is subsequently convicted for raping her at around that time.
But they didn't know that at the time. They didn't know that she was being raped.
No, they didn't know because they didn't investigate. What we're saying is they assumed responsibility for looking into a serious allegation. If a child is reporting that her stepfather has touched her breast, that's something that social services' role is to investigate.
Using experience in the criminal courts, if there was an adult and a child in a swimming pool, there could be accidental touching. And that was exactly a case which I was involved in. And so the very fact that there is a touching of the breast doesn't tell you anything.
Well, it tells you that she has reported that Mr. Austin has touched her breast. So if she has reported it, she's concerned about it. She's not saying, if it turns out it's a false...
Where's the allegation that she's concerned about it?
Well, why would she report it if she wasn't? And why would they be resolving to do keeping safe work with her if they didn't think it was a sexual assault? I mean, they're saying they're going to do keeping safe work with her as the first step in trying to protect her, but they just simply don't do it.
And if I can just take you to page 166, which is the other allegation. These are the two allegations upon which there is an assumption of responsibility. And that is that the mother had assaulted the first claimant. What does that mean?
Well,
what sort of assault is that?
but that's...
Is that an assault of really worrying type, or what sort of assault is it?
That's the task, is to look into it. I mean, until it's looked into, social workers are given reports of serious allegations. They can't be expected just to accept them, but they also, if they are discussing at a meeting that this claimant has reported that she's been touched on the breasts by her stepfather, then the assumption of responsibility is to take responsibility for seeing whether this is a serious assault or not. It's not one can't jump to, and therefore they should have taken care proceedings. All we're saying is once you have a serious allegation and you are aware of it in relation to that particular child, and you are saying that we need to look into it. The reasons they didn't look into it, we say, are bad ones. That may go to breach of duty, but it's not that they said, well, touching the breast, it must have been accidental. The reason they don't look into it is because they were fearful of how Mr. Austin would react, and because it was wrongly thought there'd been no previous similar concerns. So the reason, if there was an assumption of responsibility, it would be taking on the task of seeing whether it was a concerning sexual assault or whether it wasn't. But their reasoning is not that it isn't serious. Their reasoning is that they wrongly haven't taken into account actually that he's a Schedule 1 offender and that there have been other complaints. But nevertheless, they say we need to do some keeping safe work, and then they don't do the keeping safe work. So there's taking on responsibility for doing keeping safe work with a child who's made a report of what looks to most people like a sexual assault, because that's why it's been reported, and they're simply not doing what they're assuming responsibility for doing, which is the keeping safe work.
Ms. Gumbel, does your case really come to this? You accept, I think, that the general duty which the local authority has to all children within its area towards securing their safety and well-being doesn't give rise to any private law claim. But the moment when the local authority or anyone for whom it bears vicarious responsibility has that general obligation, as it were, focused upon a particular individual and does anything towards discharging that responsibility to that individual, then they've assumed a responsibility and a common law duty of care arises. I mean, does it go that far?
Well, not...
It sounds as if it does, but I'm not quite sure where it falls short of that.
No, it assumes responsibility when there is a known risk of harm to that child, because it is the only authority that can protect the child, because the child is in this very vulnerable situation where the parent isn't going to protect them and no one else is going to protect them. So the local authority is assuming responsibility. Obviously, it's not anything that's done in relation to an individual family. If they're visiting every house in the street to see who's moved in and whether the children are all right, they're not assuming responsibility. They're assuming responsibility because there is a specific complaint about something which should be considered as worrying. So it's not until there's a worrying aspect of an individual complaint in relation to a child who, if they were older, could make the complaint directly and could be reassured by the local authority that something would be done. What I'm saying is you can take that backwards to the child who can't specifically articulate it, but you have got to have something that they are looking into which is of concern. And that is their job, is to protect children in those circumstances. But the general duty of looking after children in their area doesn't mean that if anything goes wrong for any child that they haven't found out about, they've got a duty.
No, I wasn't suggesting your case went in relation to children about whom they had no cause for concern. But you say the trigger, as I understand it, is a cause for concern about a specific child, and that's sufficient.
And we would say it's not that different from a doctor who sees a child and has a duty to that particular child. It's a professional. I mean, I think they even call them clients now. They have a particular child who they are responsible for looking after in a situation of risk.
Well, and Poole is wrongly decided, because there was a specific concern about two children. But you say that in those circumstances there would be a duty of care would arise.
But in Poole, there were a number of different difficulties that don't arise here, because the children were not at risk because of the home situation, and therefore it wasn't a situation for looking at a care order. And the problem in Poole was, it was, as we would say the X and Y and Hounslow case was, a case of the housing arm of the local authority don't have a duty to rehouse families who are in unsuitable accommodation. And ultimately, that's what X and Y decided. The Social Services Department could have been liable, except that the social worker was found to be blameless. It was the housing arm, and I'll come to that later in answer to my learned friends taking your lordships to that case. So that in CN and Poole, the complaint was really that the children weren't rehoused rather than that they should have been removed from home. Although I appreciate that there was an attempt to argue that that was the only way you could keep them safe, was to take them into care, but that was clearly found to be wrong both by the Court of Appeal and by this court on the basis that it wasn't the lack of care by the mother that put them at risk. It was the neighbours and their housing situation that put them at risk. But N Poole, we would say, established that there can be an assumption of responsibility. On the facts of that particular case, there wasn't, but it did leave open, we would say, didn't, as my learned friend has suggested, say there will be very rare and exceptional cases where there can be an assumption of responsibility. We would read it as saying there can be an assumption of responsibility where the facts are right, and they're not right. In this case, there isn't a pleaded allegation that amounts to assumption of responsibility, but it didn't rule out an assumption of responsibility in the example I've given or in the examples of this case. Can I turn to the history? Because I think the way that the social services cases have developed, and I will do so briefly, but I think it is helpful to see how the House of Lords from Exham Bedfordshire and the subsequent cases have looked at the category of social work responsibility and social workers as professionals, because it was a category of case that really only started in 1994 with the Exham Bedfordshire litigation. So I would start with how Sir Thomas, being a master of the rolls, saw the litigation. Obviously, his judgment in the case was a dissenting judgment, but I go to it only to show how this was a new question and what the issue really was. At EF 1806 in the behind tab 20 of the main authorities bundle. The Exham Bedfordshire report is both the report of the Court of Appeal decision and the House of Lords decision. To 1806, and I go to this because this is the start of the investigation of how do we look at a social services department and social workers as professionals.
We can see that you and Lord Fawkes have been involved in these cases for a very long time.
Yes, I think, unfortunately, we've not managed to resolve it in a way that satisfies everybody, and we're back here. 1806, Sir Thomas Bingham, Master of the Rolls, these two appeals have been heard together. In fact, and so this is the Exham Bedfordshire and Emmon Newham cases. The Exham Bedfordshire was 5 children who were being abused at home. They were locked in one room and feces were smeared on the walls. They had no bedding, and it was a neglect case. And Emmon Newham was the child who was taken into care when she shouldn't have been, because the man she was saying abused her was not the person they thought it was. These two appeals have been heard together. The facts in the two cases and some of the issues are quite different, but common to each case is a question of great importance and difficulty. May a child maintain an action for damages, whether for breach of statutory duty or common law negligence? And as I say, at that stage, the cases were brought in the alternatives of breach of statutory duty, but that was, I think, the only time that that occurred, or the only time in any of the appellate decisions, against the local authority for steps taken or not taken in relation to the child by that authority as a responsible social services authority. And then it had been answered negatively up until that point in each case. And then at 1994, I'm sorry, at 1806,
1806.
and then at EF 1815, at letter C, obviously the Master of the Rolls was dissenting, but this was the basis of looking at local authority responsibility at that stage, at letter C. I do not think the facts of these cases are covered by existing authority, so this, we would say, is the first case where social services responsibility was being looked at. The relationship between the child and the mother and the psychiatrist was not on any showing a typical doctor-patient relationship. I'm not aware of any previous litigated claims by parent or child against a social worker. This, again, cannot be seen as a typical relationship between the client and professional person. It is accordingly necessary, in my opinion, to examine the various relationships involved in these cases in a little detail, bearing in mind the principles in the decided cases. And then at 1823, at letter D, starting at letter C, it was suggested the County Council could not be under a duty to protect the children against harm caused by third parties, their parents, and that the County Council could not be held liable for its admissions. But if the County Council owed the children any duty, as I think it did, and he was the only judge in that litigation who did, but it's just the reasoning was such duty must have embraced the duty to take reasonable care to protect the children against sources of harm of which, on the facts pleaded, the County Council was very well aware by taking such steps as any as were justified to move the children out of harm's way. Any other conclusion would be an affront to common sense. The House of Lords, and the main speech being that of Lord Brian Wilkinson, ruled out any duty of care being owed, but did so entirely on policy grounds, and gave 5 reasons why on policy grounds there shouldn't be a duty of care owed at all. What was conceded was both foreseeability and proximity. So the case was ruled out on the just, fair and reasonable basis because this was the first time that social services liability was being looked at. And that's why I'm looking at this, because the need to show the just, fair and reasonable test satisfied was clearly because this was the start of any litigation involving social services. So at that stage, it was necessary to show foreseeability, proximity, and that the just, fair, and reasonable test was met. And at 1904 are the reasons given by Lord Brown Wilkinson for not finding a duty at that stage. And I think this is important in the history. From letter D, that Lord Brown Wilkinson was applying the Caparo three-stage test to see whether, in relation to this new area of responsibility, as Lord Bingham had identified, it was just, fair and reasonable to superimpose a common law duty of care, and that's at letter F. Is it then just fair? Is it then just and reasonable to superimpose a common law duty of care on the local authority in relation to the performance of its statutory duties to protect children? In my judgment, it is not. Sir Thomas Bingham MR took the view with which I agree. Public policy considerations, which has the first claim on the loyalty of the law, is that wrong should be remedied, and that very potent counter considerations are required to override that policy. But in this case, it is overridden, and so it is entirely on policy considerations, and he then sets out the reasons for the next 3 pages, including other remedies, and finally, in deciding whether to develop novel categories of negligence, as at letter B on EF 1906, in deciding whether to develop novel categories of negligence, the court should proceed incrementally and by analogy with decided categories. So the reasoning in Exon Bedfordshire was, in effect, the ruling out on policy considerations of a duty of care being owed whatever the circumstances. And if my learned friend's submissions are right, we are in practice reverting to that situation. If he is right that rarely, if ever, will there be an assumption of responsibility, we are back to the Exon Bedfordshire position. But the litigation didn't stop with Exon Bedfordshire. It moved on to a situation where there were circumstances in which local authorities could be held liable. The first movement in that being the Barrett and Enfield case, which my learned friend has taken your lordships to, that can be interpreted as only being decided because of Osman and Phelps, but that's not what the other judges decided. It was found, and I of course accept it was only found it was arguable, but no one's gone back since and said you never could establish a duty of care even with a child in care. It's the subsequent cases accept that a child taken into care can be owed a duty. And then, following that, the D&E Berkshire litigation moved on the position from Barrett and Enfield, and only when the position where only when a child was in care could there be a duty of care owed. And the explicit reasoning incorporated child protection and suspected child abuse in a range of circumstances. And if I can just go to the relevant passages. It's at EF 1236. Is the start of the decision, and at 1268 was where it was said that the policy reasons paragraph 83 insofar as the position of a child is concerned, we have reached the firm conclusion the decision in Exon Bedfordshire cannot survive the Human Rights Act. Where child abuse is suspected, the interests of the child are paramount, in Section 1 of the Children Act, given the obligations of the local authority to respect a child's convention rights, the recognition of a duty of care to the child on the part of those involved should not have a significantly adverse effect on the manner in which they perform their duties. In the context of suspected child abuse, breach of a duty of care and negligence will frequently also amount to a violation of Article 3 or Article 8. The difference, of course, is that those asserting the wrongful acts or omissions occurred before October 2000 will have no claim under the Human Rights Act. This cannot, however, constitute a valid reason of policy for preserving a limitation on the common law duty of care, which is not otherwise justified. On the contrary, the absence of an alternative remedy for children who were victims of abuse before October 2000 militates in favour of the recognition of a common law duty of care once the public policy reasons have lost their force. Follows, it will no longer be legitimate to rule that as a matter of law, no common law duty of care is owed to a child in relation to the investigation of suspected child abuse and the initiation and pursuit of care proceedings. It is possible there will be factual situations where it is not fair, just or reasonable to impose a duty of care, but each case will fall to be determined on its individual facts. So the actual finding in D&E Berkshire was that the policy considerations being swept away from the Exon Bedfordshire litigation, it was no longer right that in a wide range of child protection issues, you would not have a duty of care on policy reasons, Exon Bedfordshire only providing policy reasons for a duty of care not being owed. And the position in D&E Berkshire, whilst it can be the facts of the particular cases can be analysed to confine its ambit, it is right to look at what the House of Lords, in looking at the parents' appeals, said about the decision in relation to the children, and that's at EF 2329, tab. Sorry, I think that is in the second bundle. It's
The only case in East Berkshire appeal, the only case where the court upheld a duty of care was the Dewsbury case, wasn't it? Where there was a positive intervention by the local authority causing actual harm.
Of course, and that's what was said in Edinpool. The reason I've gone to that passage is one doesn't get from that passage that the Court of Appeal at that time intended that it would be restricted to where the local authority caused the harm. Of course, the facts of that case were a wrongful removal rather than failure to remove. But I've taken your lordships to that passage because it obviously is much what was intended by that passage is not restricted in that way. It is much wider. It's in the, as I understand it, what the Court of Appeal was saying is Exon Bedfordshire ruled out a duty of care in the social services sphere on policy grounds. Those policy grounds have now gone. You can no longer say there can never be a duty of care owed by the local authority in child protection work. And it didn't indicate that you would have to cause harm in order to have a duty of care. And what I point to is that Lord Nichols, when the cases of the parents were heard in the House of Lords, also reiterated that wide interpretation of what the Court of Appeal had said in D and East Berkshire without dissenting from it in any way. And the House of Lords decision in D and East Berkshire is behind tab 35. It begins at EF 2329, and I'm looking at paragraph 82 at EF 2361. And this is making the point that there is the House of Lords were concerned with the claims by the parents whose child had been wrongly removed as to whether they had a claim. And in paragraph 81 is emphasising there's a distinction between the parents and the children. So the crucial question on these appeals is whether this potential disruption of family life tilts the balance in favour of imposing liability and negligence where abuse by a parent is erroneously suspected. Then paragraph 82, there is little authority directly on this point. This is not surprising because the law has been developing remarkably swiftly in the field of child protection. Until recently, it would have been unthinkable that health professionals owed a duty to parents. They did not owe a duty even to the child. But the law has moved on since the discussion of your Lordship's house in Exon Bedfordshire. There the House held it was not just and equitable to impose a common law duty on local authorities in respect of their performance of the statutory duties to protect children. Later cases mentioned by my noble and learned friend Lord Bingham have shown that the proposition is stated too broadly. Local authorities may owe common law duties to children in the exercise of their child protection duties. And again, there is no suggestion that that's restricted to where they cause harm. It's simply they may owe common law duties in their exercise of child protection duties. And the history of the cases is set out by Lord Bingham, again in a dissenting judgment, but the other judges adopt the analysis, the history, and Lord Bingham at page 2343 just emphasises that in holding it was not just fair and reasonable to impose a duty of care on the healthcare professionals towards the claimants in Exon Bedfordshire and Emma Newham. So it's both the cases of the children not taken into care and the child taken into care wrongly. The House of Lords was strongly influenced by policy considerations identified in the opinion of Lord Brown Wilkinson, which, although much quoted, he then repeats. And those policy considerations having gone, there is no suggestion at this stage in the development of the litigation in relation to social services that there is a distinction between causing harm and not protecting in the child protection sphere. And then following D and East Berkshire, there was the case of Blewett and Suffolk, which is a Court of Appeal decision, which is significant because it's a decision finding there could be an assumption of responsibility in respect of a child who was not in care, so it didn't rely on the Barrett and Enfield distinction. That's at EF 1222, so 1222 at tab 5.
Sorry, the page number again, please, sorry.
Sorry.
The page number again.
EF 1222.
Thank you.
It's in volume 1, and it's the head note, I think, sets out the decision. That's at 1223. Decisions of social workers were capable of being held to have been negligent by analogy with decisions of other professional people. It might well be necessary to conduct a detailed factual inquiry. In the instant case, not all the substantial facts relevant to the allegations of negligence and which were reasonably capable of being before the court had been before the court. There were the bones of a possible case that the hostel had been known to be one which was materially insecure and risk of dangerously violent incursion by intruders. This was a child who was not in care, who was placed in a hostel by social services.
But I mean, this looks like a causing harm case, isn't it? You take the child, you put them somewhere dangerous.
Well, it wasn't analysed in that way. It was that you've assumed responsibility for housing them.
It was 19 years ago. I mean, the way cases are analysed obviously has changed in the last 10 years.
Well, indeed, this is why I'm going back to have what the point I'm seeking to make is that whilst at the Exon Bedfordshire era, it was necessary to apply the Caparo test because this was the beginning of social services investigation, that I'm seeking to show that we've moved on from that and that there have been a number of cases which have looked at the particular facts and whether there is a duty of care, so that we are no longer in the territory of having to apply the Caparo criteria and to find in relation to particular cases that it is just, fair and reasonable, because there is now an established body of cases in which social services can be found to owe a duty of care. And I'm only pointing to this case because it isn't confined to cases in which a child is formally in care. And this is an example of a case with a duty being found. East Berkshire sets out that there can be duties in relation to child protection work generally, and then following that there is a case in the Court of Appeal which doesn't rely on Barrett and the distinction between a child who's in care, which, as I understand it from my learned friend's case, is the only situation where there is likely to be a duty of care owed by social services is where there is a care order, and Barrett seems to be the only area in which it's accepted there can be a duty owed. It's accepted there might be hypothetical exceptional circumstances where there was an assumption of responsibility, but my learned friend wasn't able to give any example of a case where he would accept that would be the case. So I'm seeking to show even the decided cases are not restricted to the Barrett and Enfield criteria. That's the reason I'm pointing to that. So what we say the position that has been reached is, and by the point of the decision of N and Poole and the consequence of the decision of N and Poole, is that there can be a duty of care owed to a child in the context of child protection work by social services where there is an assumption of responsibility, and that assumption of responsibility is not confined to cases where the child is in care. It depends on the facts, and where those facts give rise to an assumption of responsibility is still, we would say, a difficult question for judges, even if the judges asked to strike out these cases thought they could determine it on the basis of N and Poole, but the determination was simply that all cases are struck out other than those where there is a care order, because that's in effect what the judges who struck out this case below the Court of Appeal found, and the Court of Appeal found that it wasn't that straightforward and that it would need to be looked at, that the decision in N and Poole that there could be an assumption of responsibility, but it would be fact-specific, has left the courts with two options, really. Either, well, we're going to strike out all the cases, which is the view that was taken by the lower courts in this case, or the view of the Court of Appeal, which is we've got to build up a body of cases looking at individual examples to see where it can properly be said there's an assumption of responsibility, and that a trial is what's necessary to do that, to rely on the DXF case showing that once you get to trial you're bound to be struck out, which I think is, or bound to fail, is not really determinative of whether all cases must fail. And we would say if this appeal succeeds and the Court of Appeal are wrong to say that the facts of these cases need investigation at trial, it is very difficult to see how there will be any cases on which an assumption of responsibility will be found. And that's perhaps best illustrated by my learned friend not being able to think of an example.
Well, you've in a sense already accepted that where there is a care order in place, that might be a different case. So I think you said, developing the history, that the two options, strike out all cases, but I think you'd already accepted that an exception to that would be care orders.
Well, all cases except Barrett cases. I think everybody's accepted that Barrett and Enfield, where there is a care order, although I think my learned friend was suggesting that Barrett might be re-looked at by this court as to whether it went too far. I may have misunderstood, but that's what I'd understood was being said, that might need revisiting. But what I'm saying is all cases where there isn't a care order. And if that had been the intention in N and Poole, as we say in the case, we would have expected the court in N and Poole to say, we have a dividing line, it's cases where there's a care order and cases where there isn't. but that isn't what was said in Ellen Poole, and I do want to go to some of the passages in Ellen Poole that make that clear, that there will be cases. It's where we would say that judges haven't had enough assistance as yet in defining where where they can find an assumption of responsibility, and the answer simply to strike them all out because we don't know where you could find an assumption of responsibility is not a satisfactory one. We go to Ellen Poole and see where in Ellen Poole we rely on the findings that this area has still cases that won't be struck out because there has been an assumption of responsibility.
Before doing that, I wonder whether I could ask the following question, and that is that my understanding when I look at the pleadings at 166 and 171 in relation to YXA, that you're saying that, for instance, in relation to the assault, there is an assumption of responsibility to investigate. Do I understand you correctly?
There is an assumption of responsibility to protect that child for whom you know there is a complaint of a sexual assault. How you do that will be in a number of stages. Obviously, the first stage is investigating, because without further investigation, you're not going to be able to determine whether it's appropriate to apply for a care order. We say on the facts of this case, proper investigation would inevitably have led to an application for a care order.
That's the next point that I wanted to understand. If it is an obligation to investigate, a common law duty to investigate, you're saying that there's another stage, and that is that if they had investigated, as night follows day, they would have found out more facts, which would have given rise to another obligation, an assumption of another duty, and that is a duty to bring care proceedings.
No, I'm afraid I would put it slightly differently from that. I would say that the assumption of responsibility involved a duty to investigate competently, and competent investigation could only have resulted but that's factual causation.
Well, I just don't, I'm afraid, I'm sorry. Competent investigation frequently does not reveal further facts. And so that is a jump from one stage to another. There are many occasions when lies are told, children are influenced to say things that they shouldn't say, they're under the control of their parents, and further investigation doesn't reveal anything of any note whatsoever.
But that is going into, we would say, in the context of this case, if there is an assumption of responsibility to, I would say, competently investigate, because obviously incompetently investigating is not going to help anyone, and whether that competent investigation would inevitably have led to a care order is a matter of factual causation for a trial judge. Because what was there to be found? There was that the stepfather was a Schedule 1 offender. He'd been raping the child for 4 years at that stage. And it would be for a judge to decide, but it seems inconceivable that competent investigation wouldn't have identified that she wasn't safe in that home and that she needs to be removed. But that is the consequences of having assumed responsibility to protect the child in whatever way turns out to be appropriate when you do the investigation.
But where's the pleading in relation to the stepfather being a Schedule 1 offender, and where is it pleaded what offences he's committed?
Sorry, can I just... I'm sorry, just...
Well, at some stage. Yeah. I mean, don't take up time now, but I would like to know exactly where that is pleaded.
I will, perhaps overnight, I can look at the pleadings and come back with a fuller answer in relation to that. But certainly the facts, we say, on investigation, and that may be, part of when I come to why it shouldn't be struck out but go to trial, is those are the kind of matters which are typically needed to be investigated at trial as to what facts would have been revealed and what...
It's your obligation to plead how they assumed responsibility. And if you are pleading that a full assessment would have revealed certain facts, then they should have been pleaded.
Well, can I look overnight again at the pleading? And can I then turn to what was said in and Poole in relation to assumption of responsibility. It's the decision is in the main bundle of authorities, tab 15, EF 1595. And the question set out at paragraph 1, which is at letter B, the principal question of law which is raised is whether a local authority or its employees may owe a common law duty of care to children affected by the manner in which it exercises or failed to exercise those functions, and if so, in what circumstances. And then at 842G,
Or is that electronic 1628, do you mean?
at EF, paragraph 86 onwards, at EF 1628. There is the reference at paragraph 86 to, in considering, at the bottom of the page, in considering the question, may be helpful to compare the position of social workers with the positions of the educational psychologist and the advisory teacher in Exton, Bedfordshire, and Phelps and Hillingdon. And I'll come to what help we get from those in a moment. And then the concept, paragraph 88, as has been explained, however, the concept of an assumption of responsibility is not confined to the provision of information or advice, can also apply, whereas Lord Gough put it in Spring and Guardian Assurance, the claimant entrusts the defendant with the conduct of his affair in general or in particular. Such situation can arise where the defendant undertakes the performance of some task or the provision of some service for the claimant with an undertaking that reasonable care will be taken. Such an undertaking may be expressed, but is more commonly implied usually by reason of the foreseeability of reliance by the claimant on the exercise of such care. In the present cases, however, nothing in the particular claim to suggest a situation of that kind came into being. The existence of an assumption of responsibility can be highly dependent on the facts of a particular case. Where that appears to be a real possibility that such a case might be made out, a court will need to decide will not decide otherwise on a strikeout application. In the circumstances which I have described, however, the particulars of the claim don't, in my opinion, set out a basis on which an assumption of responsibility might be established at trial. But that is not suggesting that it will be very rare in the context of social services claims generally that there could ever be an assumption of responsibility. It is that on the facts of the cases in CN and Poole, there wasn't the factual background on which an assumption of responsibility could be established at trial. So that to say now that rarely, if ever, will there be an assumption of responsibility is taking the decision in N and Poole, we would say, beyond what is suggested by the judgment itself. And if confined only to the Barrett and Enfield situation, it's surprising that it doesn't make that restriction on assumption of responsibility in the context of social services cases. So that the factual background is important. And at 892, at 1625, it's expressly stated in paragraph 75, the first consideration of which Lord Justice Irwin placed particular emphasis, namely the concern expressed in X and Bedfordshire that liability and negligence would complicate decision-making in a difficult and sensitive field, potentially direct the social worker or police officers into defensive decision-making, has not been treated as sufficient reason for denying liability in subsequent cases. His view that the decision of the Court of Appeal in D and East Berkshire had been implicitly overruled in Michael was mistaken. The decision in D and East Berkshire has not been overruled by any subsequent decision. And that is expressly stated, and it was one of the reasons for finding for the reasoning in the Court of Appeal not being accepted. The Court of Appeal had effectively returned to the Exon Bedfordshire situation and said that D and East Berkshire, effectively said D and East Berkshire, being a Court of Appeal decision, couldn't overturn Exon Bedfordshire. Exon Bedfordshire was still the law, and D and East Berkshire was wrong, and that is not how N and Poole has left the sequence of events. N and Poole has reinforced that Exon Bedfordshire and the policy decisions no longer do apply. Barrett and Enfield is one stage on. There can be a duty where there's care proceedings, but it is not the only situation, and it would have been easy to have said so if that was the intention. So if I can turn now to what I say is the test for assumption of responsibility.
No, that's an important stage in your argument. Would it make sense for us to adjourn now and...
My
Can I
lord,
just
yes.
ask-
Is that tomorrow? Yes.
One question I'd like to ask is, are you, is it part of your submission that both these cases stand or fall together?
It isn't, no.
No.
I think we clearly say that in the written case, that
Right.
no, they are separate cases. They have been heard together, and they do raise different issues, and importantly, different issues. If Section 20 is a different area, that would need to be
Maybe you could
stated.
just help me with this. In a sense, at a high level of generality, the problem that we have here, because we know that that we're trying to sort out when public authorities should be treated in the same way as private individuals. And the problem we have is that we're dealing with failure to benefit cases. Now, the starting point for private individuals is that there is no duty of care in relation to failures to benefit. So we need the assumption of responsibility to get over that problem. Now, if we go to the classic hypothetical of the drowning child, I think it would be fair to say that there is no assumption of responsibility subject to something extraordinary until somebody at least attempts the rescue. So you can walk on by, but I would also suggest to you that you can ask what the position is with the drowning child without at that stage assuming any responsibility at all to investigate any further. In other words, there is no duty of care to investigate in relation to the child. So that is the situation we're actually dealing with. Now, I think you're putting into the equation, but the child here is making a complaint, in a sense, and then there's an assumption of responsibility in response to that complaint that you have to competently investigate. But the analogy would be the child makes quite clear that he or she is drowning. As I understand it, the common law would still say the defendant doesn't have to do anything. It's only once they assume responsibility, i.e. do something to effect the rescue, that there's a duty of care at common law.
But the other distinction is the professional relationship, because there are three different situations. There's the drowning child and the passerby. Then there is the public authority, fire brigade, police, who have general duties that people can rely on them to do something, but they're not the specific focus of a particular complaint and a particular call-out, as with the ambulance case, Kent and Griffiths. Once you were a particular patient having an ambulance called out that simply didn't leave the ambulance station, there was an assumption of responsibility. But there is the professional and doctors in relation to their patients, where they have a specific professional relationship, do have to stop harm, because that's most of what they're doing. So stopping harm is not a parameter that distinguishes cases where there is a professional relationship. It's only a parameter that distinguishes cases, members of the public with no relationship. So this is in between, because there is a professional relationship, albeit it's with a statutory backdrop, but it is nevertheless a professional relationship of social worker and client. So it isn't analogous, we would say, to the drowning child. Does that...
Yes, thank you very much.
Just very briefly, I think it's DFX who is a Schedule 1 offender, not HXA's the live-in partner of HXA's mother. But you'll no
He
doubt
did
tell
have
me
a
tomorrow.
conviction for shaking his 8-month-old baby, as I understand.
Right. Okay. Well, if you can
That
give us the
he
details
was
tomorrow, I'd
convicted
be very grateful.
of I think brain damaging his 8-month-old baby by shaking him, or certainly seriously injuring him.
I have a very short question, Ms. Carwell. You took us to that part of the pool case which deals with assumption of responsibility by the social workers on the basis of a vicarious liability claim against the local authority. There's a quite separate part which deals with the assumption of responsibility, or otherwise by the local authority itself, slightly earlier in the judgment. Do I take it that because you're referring to the vicarious part, that you're putting your case mainly on there having been an assumption of responsibility here by the social workers for which the local authority is vicariously liable, or are you putting it both ways?
Both ways.
Okay. Thank you.
There
That's
is
my only question.
the distinction between the direct liability and the vicarious liability was emphasised by Lord Brown Wilkinson in Exon Bedfordshire, where he didn't think anybody's pleadings made that distinction clearly enough, and it should have been made. In practice, certainly in clinical negligence, it's nearly always is vicarious liability because local authorities and hospitals act through their doctors and social workers, but it can be direct liability as well, where the system is, where it's a systems failure.
Well, we'll adjourn now and resume at 10:30 tomorrow morning.